Hi, everyone. Julie Pinessi here. It's now been 3 weeks since that week when, perhaps more so than any other in Canadian history, we were all left wondering, what it means to be Canadian, what our laws really are, what civil liberties are in Canada, and what force, if any, our Constitution really has. 3 weeks ago today, our Prime Minister invoked the Emergencies Act for the first time in Canadian history. And 2 days after that, without anything substantial having changed scientifically or in terms of the truck convoy in Ottawa, he revokes it. And for many, it wasn't clear that we didn't have other legal approaches or apparatus that could have better handled the protests in Ottawa, Windsor, and in Alberta. And for many others still, it wasn't clear that we were in any kind of state of emergency that warranted the use of the extraordinary defense measures at all. And when this sort of thing happens, I think it makes sense as citizens to think and talk about where we're at and what's happening in our country and what that says about how we are evolving and where we might be headed. Last week, I had the pleasure and privilege of sitting down with legal scholar and executive director of Rights Pro, Bruce Pardy. And we chatted about so much. I learned so much from the conversation. We chatted about, how much freedom we really have in Canada right now and why autonomy and Canadian civil liberties have lost their footing. We talked about where in the world this collectivist approach to law came from and what the government and judicial response to the COVID situation has in common with affirmative action of all things. So as I said, I had learned so much from chatting with Bruce, and I really enjoyed the conversation, and I hope you'll enjoy it as well. Seems to me like we've been through the ringer politically, psychologically, legally over the last 2 years, but especially over the last couple of weeks since we can call it the end of the convoy in Ottawa. Like, as a legal scholar, what are you seeing? Where do you think we're at in Canada?
So the first observation I would make is that the place we are seems sudden, as though it's come on in the past 2 years.
Mm.
And in some respects, it has. I mean, we sort of crossed a threshold, and things are different in a way. But it's a big but. We've been traveling this path legally for quite a while, and so I'm shocked but not surprised, if I can put it that way.
So by this path, you mean what? Can you kind of flesh that out a little bit? Because I think most of us don't have much of an awareness of what the laws are in Canada, how they get worked out in the courts, how our foundational documents like the Constitution are meant to apply, what kind of force they have. So can you just kind of tease that out a little bit for us?
Sure. So perhaps the first thing is to perhaps to try to displace a belief that some people carry around it with them, which is that regardless of what else is happening in society or in the culture, that the law is there, it's solid, it's in black and white, and it's a
Immutable.
foundation, it's immutable, it will protect them. And that's just not the way it really works. The law is the product of the culture, and as the culture moves, so does the law. And in fact, in our case, it might even be more extreme in the sense that the legal culture has been changing for decades, really. And in some ways, it has led the cultural changes that we have seen.
Mm.
It has sort of laid the ground for a lot of these changes to be made. So let me just give you one concrete example.
Mhm.
We have an equality provision in the Charter of Rights. That provision appears to say that everybody is entitled to equal treatment under the law, meaning that the same rules and standards apply to everybody. And then there's a subsection, a section, a part two of that section that says, oh, and by the way, it's okay if you have affirmative action. Now, they don't call it affirmative action, but that's essentially what they mean. So at the time that this was put in place, this is the early 1980s, we had affirmative action programs, or at least they were on the horizon, wherein you gave special treatment to certain groups. And so those two subsections were designed, in my opinion, and drafted to work together. The first one was essentially a statement that the same rules apply to everybody. And the second one was, well, except if you have one of these programs. And what has happened since that time is that the Supreme Court of Canada has taken the first part of that section and said, oh, no, 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 no. That doesn't mean the same rules apply to everybody. That requires equality in a different sense, in a substantive sense. That is, it's not equal treatment, it's equal outcome. And if that means that we must apply different rules to different people, different groups, well, then that's what this section requires. So most recently,
interpretation at the level of the Supreme Court judges.
I'm sorry, say that again.
This is an interpretation that's happening by the Supreme Court judges.
That's correct. And of course, this is the dynamic that happens with laws in general, right? So you have words on the page in statutes or in constitutions, and then those words have to be interpreted by courts. And then one of the live issues always in the court is, to what extent is the court free to place its own creative interpretation on those words, or are they committed to a narrow interpretation boxed in by the actual words and boxed in by what courts previously have held those words to mean? And we can get into that. That leads us into the living tree and the degree of control that courts are supposed to have over social policy and so on. But in this particular situation, what the court has done over a period of decades is basically say that the guarantee to equality in the charter is a guarantee to substantive equality between groups. And so those people who are carrying around the idea that in Canada we have a constitutional guarantee of equal treatment under the law, meaning you can't make the job not open to white males, that's not true. It's just not the case. And so that might not appear to have direct relevance to the COVID situation, but actually it does, because it lays down a sort of if you like, an ideological take on the way the charter is supposed to work, and a reflection of the prevailing ideological approach that's been taken to the law in general over that period of time.
Well, can you tell us how is, okay, so let's be very basic, because in most conversations I see, words like constitution, or words or terms like constitution, Charter of Rights and Freedom, Bill of Rights, Emergencies Act are used but not explained, rarely explained. So in your view, how is the Constitution supposed to work? I mean, what kind of force does that have?
Good question.
And what's in it?
Right. So, well, let's try. I mean, it's always hard to find out what the very starting point is, but let's try. So,
little thought experiment.
Right. Exactly. So our system is basically built on the British system, and the British system has lots of principles in it, but one of those principles is legislative supremacy. That is, the legislature is supreme. And the UK doesn't have a written constitution. They have an unwritten constitution. But for the most part, they have a principle that legislatures can make any rules they like. And why is that? Well, because they have democratic legitimacy. They've been elected by the people. And they're, they don't have a charter of rights. So they don't have courts coming in and saying, well, you can't do this and you can't do that. They have the principle of legislative supremacy. And because we're built on that model, we have that principle too. So we have now, but we have one thing that the Brits don't have, which is a division between provinces and federal government. But as long as a government is within an area of their jurisdiction, they can make any laws they want. And that means that those laws do not have to be justified by evidence, by science, by social policy, by reasonableness. They don't have to be fair. They can be anything they want, anything they want. So, for example,
Mm.
if the government passed a law that said, we're taking your house and we're not paying you compensation, then that's the law. And all of the objections that say, well, but I have rights. Well, not that protects you from that, you don't. No, so find one. Show me one. Show me a right that means that the legislature can't pass a law that says they're taking your house. And you'd be hard pressed to find one. It's not in the charter because the charter does not protect property rights. We have the Bill of Rights, and the Bill of Rights is not a constitutional document. It's an ordinary statute, an ordinary federal statute passed in 1960.
So what does
And
that mean? What work in law does a statute do?
a statute is the declaration from the legislature of what the law shall be, but it's different from a constitution because the Constitution is a limitation on that principle that I mentioned, legislative supremacy. So legislative supremacy still exists,
Mhm.
but it like has a fence around it now. That's the fence of the Constitution, including the charter. So you can make laws as you wish if you're a legislature, except if it breaches one of the provisions of the Constitution, including the charter, right?
That word
But
breaches is very interesting, I would think.
I beg your pardon?
The word breaches is very interesting.
Well,
What does it
absolutely.
mean for a law to breach the Constitution or some?
Exactly so. Exactly so. So let's go back to section 15 and the equality thing, because that's the question in every charter challenge, right? So legislative supremacy, you can pass laws, you can do regulations if the statutes authorize them. So let me back up again. One of the other principles, a key principle that we have in our system, is that we have three branches of government. Yes, we have legislatures, we have the executive branch, and we have the courts.
Mhm.
And as a general principle, we're supposed to have separation of powers, or if you like, functions between those three branches.
Mhm.
The executive is the largest branch of government. It includes everything that's not legislature or courts. So if you think of the cabinet, but not just the cabinet, but also all of the ministries, all the departments, all the agencies, all the tribunals, all of the bureaucratic end of government are all executive branch. Now, the general principle is the executive branch of government can't do anything that is not authorized by a statute.
Hmm.
And that's sort of the relationship. It's an uneasy relationship, though, because the people who head the executive branch are also the people who head the legislative branch. You know, the premier in the cabinet or the prime minister in the cabinet, they're directing the legislative program at the same time they're running the government.
Mhm.
In that sense, we have a weak separation, unlike the Americans, who have a completely separate office of the president and Congress.
Mhm.
But nevertheless, the principle still applies, except that because there's sort of a collusion here between executive branch and legislature, because both branches are quite happy for the executive branch to have wide discretion to make policies and to make regulations and to fix problems on the go,
Mhm.
so that a lot of the statutes give to the executive branch this very wide discretion and lawmaking, rulemaking authority, which is
Mhm.
what has happened in this COVID area, but didn't start with COVID. So you
Mhm.
have, for example, the Reopening Ontario Act. Reopening Ontario Act says cabinet can make regulations about this and that. And the regulations say that the chief medical officers of health directives will be effectively the law. So they have given the chief medical officer of health essentially lawmaking authority. And it's all written down there. So it is consistent with these ideas that we have, the legislative supremacy and power to delegate authority. The executive branch is now using the authority it's been given. So
Mhm.
on its face, even though it sounds arbitrary, it sounds draconian, it sounds like a concentrated power in an office, and yet it's still lawful.
It's very
It's still
Canadian.
consistent with the way the system is built.
So the Emergencies Act comes along,
Right.
which seems to look like it obliterates the Constitution.
Right.
Is that the case?
No, it's actually not the case. So there's I agree with the way it looks,
Mhm.
but so the Emergencies Act is just another statute. And because it's another statute, it was passed in 1988. This is a federal statute. And no legislature can oust the Constitution even if it wanted to. So they passed the Emergencies Act. This is really it's a political signal by calling it the Emergencies Act and saying, all right, we're going to create these unusual powers that we're going to invoke only in these situations. What they basically done is say, all right, all you people, we're only going to do this kind of thing when there's a dire situation. They didn't have to do it that way. They could have just passed the statute that created these powers.
Because the nature or even the definition of an emergency involves the idea that it's anomalous.
Yes,
That we're
sure.
not in a permanent state of emergency. Otherwise, it would cease to be an emergency, presumably, right?
Correct. It was both temporary and extreme, sort of existential, like war or invasion or some kind of natural disaster, something you need to deal with right now. That is a acute threat to the country and its people.
Was that the case, do you think?
Oh God, no. No, not even close. Not even close. So
use the word like existential threat that conjures
right.
images of, as you say, kind of warfare or something that without intervention would end the lives of many, many people or something
right.
equivalent to that.
Right. So let me just go back just for a moment before I answer that question. Let me go back for a moment to the charter question, which you raised, and it's a very good one. So how is it that they can do this even though the charter is still in effect? They haven't ousted the charter, the Constitution still exists.
Mm-hmm.
How can they do this? Well, it's probably because we have in our charter, we have section 1, which is the reasonable limits provision, which basically says that even in situations where charter rights have been infringed, that might be okay if the government can show it was justified. And the way you justify it is you show the pressing problem you're trying to fix, and you show the reasonableness of the infringement that you've caused, the proportionality between the cause and the effect, and the fact that there were no other practical options about how to fix the problem, and this kind of thing. Mm-hmm. And so by invoking the Emergencies Act, you're giving a signal to the people and to the courts, for that matter, that the government thinks this is a dire situation, and therefore might justify infringing rights. And of course, that the validity of that view is for the courts to make it if it ever gets there. But in the present circumstance, what has happened, and there have been applications to challenge the invocation of the act now in process, but you know, this was declared and then rescinded 8 days or so later. So you have that period, and the Emergencies Act is set up so that the government has 7 working days, not just 7 calendar days, but 7 working days to use their powers before the invocation has to be ratified by Parliament. And so the whole thing was wrapped up before the Senate vote occurred. So to your question, now I forget what it was.
But I was going to ask you, so following along that line of thought, the Prime Minister announces that he's invoking the Emergencies Act, and then I couldn't remember exactly what you're saying. It was about 8 days later when he revoked it, and I forget the language exactly, but it was something like, upon careful consideration, and we've weighed all the evidence, blah, 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 it's no longer necessary. And there's been a lot of speculation about why he made that judgment when it didn't seem as though anything scientific or really anything to do with the nature of the protest changed in that period of time.
Sure.
And then, of course, one of the hypotheses is that, well, the debate in the Senate was looking like it wasn't going to support the Prime Minister's invocation. What is your take on that?
Well, I've heard 2 theories about why it was rescinded, and the first one was the one that you mentioned, is that the debate was not going well in the Senate, and there were a couple of really good speeches by conservative senators that put a lot of questions up that couldn't be answered. And the other rumor that I heard, I don't know if it's true, is that the banks were starting to get alarmed with the number of people who were taking their money out
Mhm.
because it seemed like not secure anymore. The confidence they had in the banking system was being eroded,
Mhm.
and so the bank said, cut it out. I don't know if that's true, but that those are two of the explanations that I've read.
Mhm.
But let's go back to the invocation for a moment, which I think was your question before.
Mhm.
There are certain in the statute, this 1988 statute, which, by the way, this version of the Emergency Act has never been invoked before. This is the
War Measures Act.
successor to the War Measures Act, right, which was invoked in 1970 by Pierre Trudeau.
Mhm.
So this was passed in 1988, and the requirements, the prerequisites for invoking the Emergencies Act is actually stated in the act. There are four different kinds of emergencies in the act. There's a public welfare emergency, a public order emergency, an international emergency, and a war emergency. And so the government, if it wants to invoke the act, has to pick one of those four things.
And this was a
And they
public order one, right?
exactly so. It was a public order emergency. So all the rules and stuff about the other three became irrelevant. But
Right.
there are certain requirements and prerequisites and definitions for something to amount to a public order emergency. There has to be a threat to the security of Canada,
Mhm.
and there has to be a national emergency. And those things are defined in the Act. The national emergency, for example, consists of one of two things. And the two things are, it's basically an existential threat. As I said, they don't use that word, but an existential threat to the territorial integrity of the country, as though you're being invaded.
Mm.
Or, which is the one that was the one that applied, was serious violence. You've got a matter of serious violence that threatens the lives, health, or safety of Canadians. And that's the one they picked. There are a couple of other requirements as well. Number one, that the nature of the problem was one beyond the capacity of a province to deal with,
Mhm.
and one that could not be dealt with under existing laws that were in force in Canada. So
Mhm.
you have all these requirements flying around. And the
Yeah.
one that they're focusing on, and the one that I don't think, frankly, it meets any of those requirements.
Mhm.
But I think the one that's most acutely, obviously not met, is the one that emphasizes or requires the existence of serious violence. So in the proclamation that invoked the Emergencies Act, that's the first characteristic of the emergency that the government was claiming to being
Mm.
tried to remedy. Serious threats or acts of serious violence.
Mhm.
So the
So what
question
in your
is,
mind would count as an act of serious violence from civilians?
well, see, this is the thing. So the public
Have
state,
precedent for this, right? We can't
there's no
point back
precedent,
to other.
right?
Mhm.
So, but my theory goes like this. So there was no violence from the convoy. There's no violence from the protesters. I mean, they were there for 3 weeks. They were, parked in the street, and the protesters, came and went. It was
And you were
crowded.
there, right?
I was there for a while. I was
You were
there
there for 2 weeks.
for, I came to have a look around and see what was going on, and to sort of give commentary where I could. The truckers had been there for maybe a week or a bit more by the time I arrived,
Mhm.
but I saw what was going on the ground. I saw the protesters on the weekends. My goodness, they were happy. They were so happy. They were
So
there with their,
happy and hugging and
they
playing
were, it
hockey
was,
in the streets and cleaning the sidewalks, and
yeah,
that's what I saw anyway.
yeah. No, I saw that too, and it was a celebration. I think my theory is that they were just happy to have found each other and to have discovered that they weren't the only ones in the country who were thinking the way they were.
Mhm. Mhm.
Um, but they were, they were singing and dancing, and there was cheering, and it was it was like being a Canada Day, basically, but a more genuine version of that.
Yeah, absolutely.
But no violence, no
But no
violence,
violence.
right?
Yeah,
So
and
so
you
the
were
question is,
there.
and at one point, a reporter asked the public safety minister, "Well, okay, you've invoked the Emergencies Act. Where's the violence? I mean, what are you talking about?"
What reporter was that?
I don't remember. I don't remember. It was a scrum. but this
Well,
was
good
on
for that reporter. That's all.
yeah, yeah.
Good
I want to
question.
give that reporter credit.
Yeah.
Basically, I mean, the specific question, if I remember it correctly, was, do you have intelligence that there are weapons, in the crowd? I mean,
Mhm.
what are you basing this on? And and the minister's response was, well, it's not that we have intelligence about weapons. It's instead, it's really the rhetoric that we are hearing. It's the expression of a political ideology.
That is not serious violence itself, is it?
That it, well, see, so no, of course not. Of course not. So what the minister basically said is, we are declaring an emergency because of the expression that is coming out of people's mouths about their political opinions.
So, charitably, what is the thinking there that we're declaring an emergency because we are seeing people saying the kinds of things that have historically led to extreme violence?
Not even that.
Not
Not
even
even
that.
that.
Okay.
Not even that. Not even that. Not even that. So the real threat here, and this is my take, but the real threat here was to their own political fortunes and ideology. It's not that there wasn't a threat, but not of sort of violence. It was a political threat. This had the potential to be the coming together of a real political opposition in this country that hasn't had a real political opposition forever. This
So,
was a coming together of people who thought, you know what, we really fundamentally don't agree with what's happening here, and we will not go along with it. So let's take another take on this. In this era, in the era of the prevailing ideology that we have right now, a lot of words are being redefined.
hmm.
Like racism is one example that I get. And the meaning of racism is now what it racism doesn't mean what it used to mean in a previous era. Racism doesn't mean taking account of people's race. In an earlier era, you would have said somebody is racist if they care what race you are, what color you are. If you treat everybody the same, then you're
Mhm,
not a racist.
mhm.
That's
So,
the definition. And
what
now,
it
of course, that word's been turned on its head, right? If
mm,
you do not take race into account and compensate accordingly,
mhm.
then you are the racist. So it's been flipped on its head. And there are lots of other terms that have been flipped. So the word freedom, you could say, has been flipped in the sense that for adherents of the prevailing ideology, freedom now kind of means both safety and to be provided with the resources to do what you want. In other words, that version of freedom requires government intervention, as opposed to the original meaning, which was the government leaves you alone.
This is a
Now,
very interesting.
hold on.
Sorry, you
So hold on.
finish.
Hold on. Here's the point. One of those terms is violence that's been flipped upside down. To these people, words can be violence. And so my theory is they've taken that literally. They think that the expression of a contrary ideological view from the protesters amounts to violence. It's certainly a threat to their worldview, but the public safety minister said, the cause of this emergency is rhetoric
And rapists, we just heard.
and rapists. This right that's come out more recently, but which is telling. This idea, which seems to have come out of nowhere.
Well, I also
that-
take it there's some kind of synonymy there. So if they are racist, therefore they are also rapists.
well,
Or
sure.
I'm not sure. It's very hard to understand because there has been no evidence forthcoming to support that claim, as far as I know.
All right. So here's where we get into the theory of all of this, right? Because this is all consistent with the ground that's been laid that I spoke about at the beginning. This is all sort of consistent with critical theory, right? So your observation, I think, is entirely correct.
Now we get to it.
There's no evidence. It makes no sense. But in critical theory, that doesn't matter, because critical theory is an anti-Western agenda, anti-Western ideology, if you like.
Anti-analytic, anti-reason.
Anti-analytic, anti-evidence, anti-consistency. All those things are Western Enlightenment things, right? So if you go to a critical theorist and say, "Well, you're not being consistent," they'll call you a racist or the like, because you're being Western about it.
That's the virtue of a privileged white man, to be consistent.
Sure, exactly so, right? So when we say, well, your accusations make no sense, that there's there are rapists in the crowd because they're racist or because they're misogynists because of the rhetoric. I mean, anybody can see that doesn't make any sense, and there's no evidence behind it, and it sounds like they're just making stuff up. But that doesn't matter to them.
Right. No, this is so fascinating. Thank you for that, or articulating it in that way. I also want to ask you about safety and security, because that came up in your interpretation of what should be protected now in Canada, which is supposed to be a democracy. And it seems to me that in the language, both within our government, within our courts, but also more colloquially among people who disagree about the COVID response, is that you see freedom on one side and security and safety on the other side, and that those are first principles. So if you disagree about which of those things is most important, your discussion can't proceed, because someone says, well, but your desire to have safety is a threat to my freedom, and the other person says, yeah, I don't care, and then so there's really no way of progressing that discussion. One question I've had is, it seems pretty easy to understand why someone might think that freedom and individual rights and autonomy are democratic ideals. I mean, if you look at the Constitution, you can't get very far before you start seeing concepts like freedom of expression, freedom of assembly, and those look like they're supporting autonomous free choice. What can we say charitably to those on the other side who want to maintain safety as a democratic ideal? Is it a democratic ideal? Have safety and security are they foundational to Canada's history? Are they relatively new developments in terms of what we value politically and legally?
Yeah, that's a great question, and there's a lot in it. The concept of democracy is a tricky one, right? Because on the one hand, it is ruled by the people. It's not arbitrary. It's supposed to be responsible and responsive to what the population wants.
Whatever that is.
Whatever that is, and it's supposed to protect us from arbitrary power. It's supposed to protect us from people seizing power beyond their mandate and all those nice things. On the other hand, it also has a connotation of rule by the majority. So if the majority thinks they believe in a certain thing and they allow the government to impose that certain thing, then the people who don't agree are forced to do it, which essentially is why one of the rationales for having rights. So the idea of a right, a constitutional right that you hold against the government, is to hold back those democratic forces, or worse, but democratic forces of the group that says we want to do it in a certain way. They're supposed to enable you to say, I don't want to do that. I don't want to do it that way. I don't have to, because I have a right that's enforceable against the state, and it doesn't matter that you've elected a government that agrees with you and is passing a law that says do this. I'm not doing that because I have a charter right, for example, to the freedom of association. Or
just to give you a little sphere of protection for privacy, a little sphere, right?
It's supposed to carve out a sphere of individuality, a place where no one else can go and tell you what to do. but we're in a state now where even, well, see, it's not entirely clear that what has happened is sort of anti-democratic. Because our democratic rules have been followed, at least formally. I mean, we have elections still. There's no real evidence that the elections haven't been conducted properly.
Mm.
That we have a minority parliament and government in parliament. The members of the legislature could have, if they wanted to, have defeated the invocation of the Emergencies Act. It's that they chose not to. So it's not like we have a dictator. All
We
the
don't have a
democratic rules are being followed.
we don't have a
It,
procedural problem with
we don't
democracy.
have a procedural problem. Correct. And see, part of the difficulty with Canada has been for a long time, but especially during this COVID period, is that it tends to be rather monolithic in the sense that there's a prevailing view.
You mean ideologically?
Ideologically, and it at least appears to be the case, and I could be wrong about this, and who really knows, but it seems like the vast majority of people are one with that basic progressive ideology. So one of the distinctions between the US and Canada during COVID has been that, at least in the US, there's been a battle going on between what the proper approach is. They have red states and blue states, and people who think this and people who think that. And there's been a real public battle about the ideology behind COVID.
Mm.
Until the truckers, that was not the case in Canada. I mean, you have provincial governments of all political stripes, hardline, all of them on COVID. You don't have a DeSantis in Florida. You don't have that, the Midwest states saying, no, we're not doing it that way. You have everybody across the board, conservatives, liberals, NDP, saying, mask up, vaccine mandates, lockdown, too bad. And the one thing that happened, triggered by the truckers, was the appearance, at least, of at least some kind of mass of people who said, no, we don't agree. We do not consent to being governed this way. Something that their political leaders would not do, refuse to do, of all political stripes, with the exception of the smaller parties with no seats in parliament.
Yeah, and even people
Right.
who we might have expected a few years prior to vehemently oppose. I mean, people like Jason Kenney and Scott Moe, and even Ford, I think, in another
Yeah.
time, another era, have just homogenized.
Exactly so. Exactly so. And so this is one thing that we'll have to find out as time goes on, whether or not this is actually a coming together of enough of a critical mass of people to actually be a political opposition, not in the formal political, party sense, but in the population, so that we do have a battle going on. That's what we need. We need a disagreement. Canada needs a disagreement about this.
Yeah. It's very interesting, right? That ironically, almost, you would think that in a democracy, there's some value to putting forth effort to come to agreement about key issues.
Right.
And yet, in this case, this COVID situation has shown us that too much agreement, too much homogeneity in our thinking has perhaps gotten us the wrong answer, or maybe just that we've lost something politically, and that we've lost respect for other citizens who do have different viewpoints, and we've lost the ability to engage with each other in respectful discourse. I mean, you look what goes on in the House, and now that we're seeing MPs and also members of the Senate speaking out against some of these COVID mandates and the unreasonableness of the Emergencies Act, the Liberal MPs and some of the NDP MPs, they don't address the issues or the questions. They just sort of regurgitate the same line and then walk away.
Right,
So we've lost, right?
Yes, all true. But in those days, I mean, there were even a handful of Liberal MPs that said, this is, I'm not sure that's a good idea, right?
Yeah.
But all of those things only happened after the truckers arrived.
Yeah.
And it seemed to be that there was, in fact, a group of people,
A groundswell of
a groundswell of agreements with the position that the truckers were expressing against the vaccine mandates and other COVID rules. It sort of gave cover to those political actors who knows, might have thought this all the way along, or might have been opportunist about it. I don't know. Probably differs from person to person, but that wasn't happening before, for the most part. There were exceptions, but not very many. And whether or not this will stick and grow now, or whether it will slowly fade in yeah, I don't know.
time will tell. What do you think makes for a good democratic citizen? It's the ideal. You look at our foundational documents, our Constitution, our Charter. You look at the
Well,
history.
democracy doesn't really work unless you have citizens who think for themselves.
I thought you were just going to put a period after work there. Democracy doesn't really work.
Well,
Thought.
some would say that. Some have made a very good case that it doesn't work. Period. Like you say,
A necessary evil is the way it's often put, right?
well, I think it's the best line is it Churchill, who said democracy is the worst. It's the worst system of all, except for all the others.
That's Plato said something like that. It's like the
Right.
seventh worst form of government or something.
Right. Okay.
Yeah.
Right. But
Humans
you
are
need
imperfect, right?
you need people who are willing to think for themselves and take responsibility for themselves. And
That doesn't sound very woke and critical theorist of you.
no, it's not. That's the problem.
I
That's
joke, but
the
is
problem.
that what's central to the idea of a democratic citizen, though? That a kind of idea of like atomistic, autonomous, critical thought. So what we've been seeing now, this kind of turning our thinking over to the experts, to the public health officials, and just saying, not my job, you figure it out for me, let me know, and then I'll
Yeah.
follow along.
Yes. Absolutely.
Problematic for democracy, you think?
But that's part and parcel of the ideology, right?
It's top down, right?
It's top down. It's the authority of experts. It's the authority of expertise. It's the idea that you wouldn't follow along and do what you're told during COVID is a challenge to the legitimacy of the whole regime.
And maybe worse than that, it's heretical, I think.
Absolutely. It's
Right?
absolutely heretical. It's a good
You're
word for it.
challenging the religion that COVID has become,
Sure.
with all of
Sure.
its sacraments and all of its virtue signaling and all of the virtues that come along with being a good COVID citizen.
Right. And that's where all the complaints about misinformation come from too. Yes. If you
say more about that. That's interesting.
Right. Well, so if you state information or an opinion that is contrary to that religious belief, then that constitutes heresy. I mean,
so
literally
interesting.
so, right?
So interesting. Let's talk about that for a minute, because this recent case, I don't know if you've seen it, the Ontario Superior Court case with Justice Pazarats, and the case is really about, right? So he rules in favor of the mother who doesn't want to vaccinate her children, but more generally, and perhaps more importantly than that, he's speaking to the use of these terms in the court system, right? Misinformation. And I forget how he put it exactly, but he said, can we even put the words unacceptable views or unacceptable beliefs together? Is that even legitimate? And what happened to critical thinking when would happen to question asking? So it's very interesting to me that we're starting to see that in the courts and becoming part of public record in that way, right?
Well, it's a terrific judgment to read. I mean, I hope it does, but it is an outlier. During this COVID period, most courts have been very quick to embrace the government narrative on all of this, and most of the challenges to COVID rules have been spectacularly unsuccessful. So one can hope, but the record so far is not encouraging in that respect.
Okay, Bruce.
And
you help me understand this for a minute, because what I'm seeing happening, in a lot of the judgments that are not like Pazarats's judgment, that are more on the other side, is they'll say, well, the evidence you're providing, the argument you're making is really just misinformation. How do I know? Well, because it's inconsistent with what Health Canada is telling us. So the way that's working then is that the representative of the court, a judge, part of the judicial system, is taking its cue from Health Canada, which is part of the executive, correct?
Yes, correct. Yeah.
Is that how it's supposed to work?
No, it's not. It's not how it's supposed to work. Right? Not at all.
Well, I
Oh,
just want to make sure we're clear so that I'm
right.
understanding, right? Because there's
Sure.
a conflation there that's happening, right? And then I'm guessing, I mean, now the government is going to say, well, we've had all of these cases ruling against the people who are accused of being misinformers. And so that just gives further credence to the policy that the government is making.
Right. So the pattern over a period of time, especially from the Supreme Court, has been a defense. Number one, a defense of the necessity for an expansive administrative welfare state. Now, that administrative welfare state is not provided for in our Constitution. Nowhere it says we're going to have, we're going to have one of these things, and it's going to take control of stuff. That's not provided for in the Constitution. But nevertheless, the Supreme Court over a long period of time has basically endorsed the idea that we have to have one of these things, and it has to be able to function in order to solve all our social problems. So that's an ideological view. It is not the case that the courts always take the government's point of view. Not at all. There are lots of cases in the books where the courts have said, "Oh no, government, you didn't do right here. You have to do it better." So let me give you an example. This goes back to our discussion about equality. So the RCMP a long time ago instituted a job sharing program for its members, a voluntary program. So if you were full-time, they only had full-time at the time. If you were full-time and you didn't want to be full-time, you wanted to be part-time, you could enter this job sharing program wherein other people who also wanted to be part-time could combine and make up a full-time position. Maybe it's half-time, maybe it's third time, or as the case may be. Open to everybody. And the RCMP had a pension program. And so what they did with the pension is say, all right, well, if you opt into the program, your pension will be proportional to the amount that you work as a part-timer. If you if you work full-time, you get a full salary. If you work part-time, let's say you work half-time, then you get half the salary. And that program was in place for a while, but it was challenged on the basis that it violated the equality provision in the charter. And the argument was this: more women than men signed up for the program. And therefore, more women than men are getting a lower pension at the end of the day than men. And therefore, although the program is available to everybody equally voluntarily, it provides for unequal outcomes. And the court said, yep, this is a program that breaches the equality guarantee in the charter. RCMP and government, you will change it so that it does not apply equally to everybody, so that everybody is not equally treated by it, so that you compensate for the fact that more women than men want to take it up. And that's an example of a situation where the court comes out against the government and says, you have to fix things, but they do so in favor of what I would characterize as a progressive cause.
Is
right?
there more of a history of the courts following the government when it comes to medical issues? Would you say?
Well, again, not necessarily. So there's a Supreme Court. There was a Supreme Court of Canada case out of Quebec a few years back that challenged the system of medical care, and the complaint was, look, we have a single payer system. We're not allowed to go outside the system to pay for our own medical care for the things that the system covers. But the system isn't able to treat me for those things that it claims to cover. So you can't have it both ways. Either the system has to respond to my needs, or you have to allow me to go get my own. And in that situation, the court basically agreed and said, yeah, you can't deny people care by claiming to be the only provider and then not provide it. And there are lots of other examples of the courts, not agreeing with the government's specific case as heard in the courtroom. But
Hmm.
in general, the court has jealously guarded the ability of the administrative state in general to carry on its functions in an expansive way, to regulate, to direct, to subsidize, to tax.
Hmm.
And in those moments where there's a contest between, um, well, less interference and a smaller government and more freedom versus the expansive administrative state and more progressive causes and so on. It's not true in every single case by any means, but the pattern has been in the one direction and not in the other.
But recently, an increasing trend towards.
Well, it goes back a long way. So this interpretation that I've described of the equality provision, the charter was enacted in 1982, and this started from the very first case that considered the meaning of that provision. So this is not a sudden thing. This has been developing for a long time, much longer than most people realize.
I just feel like there's so much. This is just a tip of a very, I'm going to mix a number of metaphors here, but a tip of a very complicated, thorny iceberg or something, and
Absolutely.
we have
Absolutely.
more
Yeah.
conversations about it. But I don't want to hold you up too long, but let me ask you. So, we're talking about kind of all the problems with the court and the blurring of these lines between the court and the executive branch. What do you take to be some of the most promising legal strategies right now among those who are trying to challenge the mandates, the COVID policies more generally? I mean, we're seeing cases against some of the churches that are they're trying not to follow some of the gathering guidelines, and we're seeing cases by students against universities for de-enrolling them, and we're seeing of course a number of the truckers have tickets that they're fighting, and people like Tamara Leach are fighting their own criminal charges. I mean, what are the most, I mean, are we looking at charter challenges being the only things that are most likely to be successful now? What's likely to fail? Where should the energies be put? What do you think?
That's a great question, and it's a question that the lawyers have been struggling with over this COVID period. Well, what's the best approach here? What's the best crack? I mean, what's the best way to be strategic? Given the record so far of attempts and failures, and the occasional success, but mostly failure. Mm-hmm. What's the best approach to take? And in my view, it is not the approach that says let's just bring it all and sue everybody and cite all the charter provisions and just throw in the kitchen sink, because it's not precise, it's not targeted, it's an easy thing to reject because it doesn't make any sense. Mm-hmm. I don't mean don't be aggressive, but I mean it's important to be thoughtful about it and deliberate, and to take those cases that have the best chance and not the ones that are likely to fail and produce precedents that will now actually get in the way the next time you try and do this. Mm-hmm. They do not have to all be charter challenges. And the charter challenges, again, have not gone well so far.
And what are the other options?
The other options are so here are just, for example, here are two in quite different areas of the law. One is to wait for a case where you can challenge the authority of an agency to act the way it is. Mm-hmm. So, for example, we have professional regulators, especially in the medical field, but not just, who are essentially telling their licensees, don't do this, don't do that, you can't say that, you can't provide, supply misinformation, even though that misinformation is really medical opinion, which the college
Christine Elliott's instructions to the CPSO as of late about
exactly
how to dissenting, right?
Correct. So the question there is, in a legal sense, has the regulator at any point overreached and gone beyond the mandate provided in their statute? Because a regulator can't do anything it wants. Its
Mm.
mandate is defined in the statute that creates it and
Mhm.
gives it marching orders, just
Mhm.
like the Emergencies Act. You can't just willy-nilly invoke the Emergencies Act if you don't meet the criteria. Same with the regulator. You just can't do anything you want.
Mm.
So you identify the most egregious kind of overreach, and then you bring an application for judicial review, because one of the court's functions is to oversee what the executive does and make sure that it's within the boundaries of the powers that it's been given. So
Mm.
if you can find a situation in which the regulator has done more than it's allowed to do, then you can establish a precedent that says, no, sorry, this is outside your area. Stay within your wheelhouse and your mandate.
Mhm.
And telling people what to say is not one of those things that you can do. So that's one kind of case that I think should be pursued. Another completely different kind of case is in the area of informed consent. So, for example, if you had somebody who went to get a vaccine and and signed the form that they put in front of you to give your consent, and then got the vaccine and then perhaps experienced adverse effects from the vaccine, and then you go back and say, all right, well, so what was the interaction like between the patient and the medical provider of the vaccine? Maybe it was a nurse, maybe a doctor, maybe some other person, healthcare provider at the clinic or in the doctor's office, whoever it was. One of the requirements of that person is to obtain informed consent. Now, and to obtain informed consent doesn't just mean shoving a piece of paper in front of you. It
Mhm.
means explaining to you what the benefits and risks of the treatment are. And if you can find somebody who's been injured by the vaccine, who did not get any kind of guidance at all on what was going on and what the risks and benefits were, then you might be able to say, look, you gave a vaccine without getting informed consent. That's medical negligence, and we're going to sue you now for the costs, compensation for the injuries that have occurred.
And of course, the challenge is in those cases is to establish the causal connection between the vaccine.
Oh yeah, no,
Yeah.
that's just one of the hurdles. There's going
And
to
so
be
many
oh
institutional
yeah,
challenges
sure,
to that right now.
sure. Yeah, absolutely. Yeah.
Well, thank you, Bruce. Thank you for that so much. That's so deep and intricately woven. And I think it'll take, how long is it going to take for us to unravel and resolve this? I mean, we're not talking about weeks here.
Oh God, no.
We're in an
Well,
identity crisis of some kind. As
yes,
Canadians,
we
as a
are. So
democracy,
this
as
is one of the things that's happened in the past little while. We've sort of seen the real face of this country, and it's not a nice one.
it's not a nice one. It's not clearly a democratic one. And if it isn't, then it sort of raises the question for us, well, what is it? And what is a democracy anyway?
We have a lot of working out to do in this country, and who knows how long it'll take, and whether or not it'll get better soon or whether it'll get worse first. I don't know. Only time will tell.
Well, I asked you earlier what makes a good democratic citizen. And I think at the very least, a necessary condition is that you're willing to talk about important things that matter to your country and to your citizens. And you've done that. You're so gracious to give us your time to do that today. So thank you so much.
Oh, Julie, it was my pleasure. Thanks for having me.
Thanks for hanging out with me today. If you enjoyed watching this video, please consider making a tax-deductible donation to the democracyfund.ca/donate.